A lot has changed in the way that green cards are being processed this year, which means that the timeline through the way that your case will be processed is so different from even a year ago. And if you have been trying out what to expect, you may be frustrated because it may seem like everywhere you turn, you get a different answer from somebody else. And that is why I'm making this video. I have been making videos regarding the marriage green card process and timeline for years. So this is an update so you can understand what is different underneath this current administration, because the process keeps shifting and changes underneath the current administration have made a real impact on how these cases are moving. So I'm going to walk you through the current marriage green card process and walk you through step by step exactly what the government is doing at each stage of the way. This way you can see how long things will take until you reach the finish line. I'm also going to cover what you can expect whether you marry a US citizen or a green card holder, and whether you do your process from inside the United States or while you're outside through consular processing. So no matter what your situation, you are in the right place. To start, I want to show you the fastest version of what a marriage-based green card process can look like, because every other thing can build off of this. This path is called concurrent filing, and it can only apply to you if you are married to a US citizen and inside the United States. Concurrent filing, otherwise also known as a one-step process, means that you file the I-130 and the I-485 together at the same time. The I-130 establishes your marital relationship, and the I-485 establishes your eligibility for residency and is the actual green card application. Once your case is filed, USCIS first sends out receipt notices. These will usually arrive within 2 to 4 weeks after filing, but of course there could be delays. These notices notify you that your case is officially in the system. They provide you with your official case number per each application. They will also provide to you your A number if you were never issued one before. But most importantly, these receipts will help show that you are currently in a period of authorized stay while your application is pending. That's why for most people, silence after the filing is normal and not an emergency. The next step is biometrics. Biometrics appointment notices are typically sent anywhere from 2 to 4 months after filing. This appointment is where USCIS will take your fingerprints and your picture and establish your identity. You will take a photograph for background checks, and typically you will attend this appointment by yourself. Your spouse does not need to come with you. One important thing to note is that the timing of your biometrics does not predict how fast your case will go. Some cases get biometrics scheduled very quickly, yet move along very slowly until the final decision. Other biometrics can get scheduled later and move forward with no issues. So just make sure you don't read too far into it. Now, while a green card application is pending, many people also take the opportunity to file for both a work permit as well as a travel permission. If you file for a work permit through the form I-765, these are typically approved anywhere from 4 to 10 months after filing. If you file for advanced parole, which is going to be on the form I-131, this can take anywhere from 4 to 8 months after filing. It is very important not to depart the United States while your advanced parole application is pending until you have actually received the card in hand. If you are on a special type of visa like the H-1B that typically allows you to depart the US without waiting for advanced parole, without causing harm to your pending adjustment of status application, then you may do so, but please double check, because not every visa type will allow you to travel in this manner. Leaving without the proper permission after filing your I-485 can cause problems on your application and even cause it to become abandoned and denied. Next, after your biometrics are taken, your case will typically go very quiet. And this is where a lot of people start to panic. But rest assured that a quiet period is quite normal. Behind the scenes, USCIS is running multiple types of background checks and identity checks, name checks, fingerprint searches, and usually doing some other internal processing and transferring your case to the final location where your case will be adjudicated. Here is where your case will typically be placed into the line for an interview. None of these things will actually generate an update online. This is also when, generally speaking, requests for evidence or RFEs can also be issued. In concurrent filing cases, you are typically going to get your RFE between 6 to 12 months after filing your case. But rest assured, just because you've gotten an RFE does not mean that your case is over or that you are in trouble. They are often just asking for updated information, missing documents, or further clarification on why you are eligible. But of course, receiving an RFE can add additional time to your already long timeline. It is an unavoidable matter of life if you receive an RFE, because no matter how well your case is put together, sometimes an RFE can get issued no matter what. Another thing that is going to add most likely the longest period of time to your timeline is your waiting period for an interview. It used to be possible to get your interview waived, but now this is not so common any longer. Now, almost every single concurrent filing is receiving a request to appear for an interview. Interview notices can be sent typically anywhere from 8 to 14 months after filing your application, and this wait time is heavily reliant on the physical jurisdiction where your case is sent and will depend on how busy that location is. And because of this, I just want to advise you that the very fast approvals of 2 to 3 months are not the norm and are not typical, and you should not plan your life around the expectation that you will have a quick approval. Once you do receive your interview notice, your interview will typically be anywhere from 3 to 4 weeks after the notice is sent. And here is the tricky part, because both spouses must attend the interview. After you've completed your interview, you'll typically be issued a decision, sometimes on the spot, but more realistically, you will receive a decision in the mail anywhere from 2 weeks to 3 or 4 months after your interview has been complete. Once your case has been approved, your green card will be mailed out within 2 to 4 weeks after the approval notice is sent out. Putting all of this together, if you are inside the United States physically and you are also married to a United States citizen, your green card case could take anywhere from 8 to 14 months to be processed. Now, if your marriage is less than 2 years old on the date that USCIS issues you your green card, then you will receive what is called a conditional 2-year residency card and not a 10-year green card. A conditional green card gives you the exact same rights as a green card holder, but with one limitation and caveat, and that is that your card itself is only valid for 2 years, and you must apply for your removal of conditions through the form I-751 prior to your card expiring. So there is an extra step and an extra hoop that you must jump through, because USCIS is going to be looking for fraud a second time. Now, if you are filing your I-751 together with your spouse, then you have a very restricted, limited time period within which to file your I-751, and that is during the 90-day period prior to your card's expiration date. This deadline is strict, and if you miss it, your case could be denied. If you file too early, your application could also be rejected. And if your case gets denied, then you can automatically be issued a notice to appear and be placed into removal proceedings. But once the I-751 is filed on time, then USCIS will issue you a receipt. This receipt notice is extremely important, probably the most important receipt notice you'll ever have, because it is proof of your pending I-751, and it actually serves as your extension notice for your green card. And you must have it with you if you want to show that you are in valid legal status. This receipt notice will serve as proof of your continuing residency, and it is also something that you must have with you if you are planning on traveling internationally with your expired 2-year green card. And this is the receipt notice that also shows proof of your ability to continue working in the United States even once your green card has expired. Currently, as of the date of this recording, this receipt notice is issued for a period of 48 months, which means that this is your extension notice for the next 4 years. Next, let's talk about what will change if your spouse is a green card holder, because this will change the equation significantly. If you are married to a green card holder, then you will fall into a category called F2A. And legally, this category is very, very different from the category for spouses of U.S. citizens. The biggest difference with being the spouse of a U.S. citizen is that you are going to be considered what is called an immediate relative, and this allows you to file the I-130 concurrently with your I-485. However, if you are an F2A spouse of a lawful permanent resident, then you may not always be able to file your I-485 with your I-130, and you may be restricted to just filing your I-130 first. And also, something very important to note is that when you are the spouse of a green card holder, if you have overstayed your visa, this is not something that can be easily forgiven by USCIS. So if you are planning on remaining in the United States in order to file your I-485 so that you can take advantage of your status becoming concurrent, that means that you must remain in lawful status during the entire time, from before your I-130 is filed up until the date that you are able to file your I-485 per the visa bulletin. However, this may not be possible for all persons, which is why this category is not always easy to file for a green card. However, once the I-130 is filed, typically USCIS will send you your receipt notice within 2 to 4 weeks after the application is received. This receipt notice will do two things. Number one, it will confirm that your application is officially in the system. And number two, it will establish what is called your priority date. Your priority date is simply the date that USCIS receives the I-130 petition. This is arguably the most important date in your case because it determines exactly when you will be allowed to file your I-485 per the visa bulletin. After the I-130 goes into processing, here is what to expect. You may end up receiving a request for evidence after it is filed. And in an F2A case, an RFE can cost you a lot of time because it will also delay the approval period of your I-130. Even if your visa bulletin becomes current during this time, if your I-130 is not yet approved, then you cannot file your I-485. As for processing times, the range here is wide. When an I-130 is filed by a U.S. citizen, it can take anywhere from 10 to 17 months. While some cases can move faster for the spouse of a U.S. citizen, typically we have found this to be the current approximate range. But when your I-130 is filed by a green card holder, this can take anywhere from 10 to 35 months. And even then, once the I-130 is approved, your case does not automatically move forward because you are bound by the visa bulletin. Because you would be in an F2A category, you must wait for your category to become current first, according to the visa bulletin at the time that you're looking to file. And here, the visa bulletin never moves up and down evenly. Sometimes it can advance significantly, sometimes it can even retrogress. So even here, this is an estimate and not an absolute science. Even some countries have a much longer waiting period than others. For example, Mexico has had one of the longest waiting periods compared to other countries. And the waiting period for persons born in this country can end up stretching into tens of years. Now, here is one important exception to this. If your green card holding spouse ends up naturalizing, then you can upgrade your category to that of an immediate relative and file your I-485 application at any time. The mere fact that your spouse has naturalized and become a U.S. citizen causes the visa bulletin to become totally irrelevant in your case. Your priority date will immediately become current and you're allowed to file your I-485 without any further delay, even if your I-130 is not yet approved. And here, the adjustment of status process stage can take anywhere from 8 to 16 months. Then after this, the green card is typically mailed after an interview within 2 to 4 weeks. Now, I'm going to share with you the timeline to expect for consular processing. But first, I want to let you know that we are accepting new clients. My name is Moumita Rahman, and I have been practicing immigration law for the past 15 years. If you would like my help on your case, give us a call at 212-248-7907. We are based in New York, but we help clients all over the United States. Now, let's talk about what happens if you are applying for a green card to come to the United States, but you're not living in the United States. This timeline will work very differently because you will be dealing with different agencies. When you go through the consular process, the first thing to understand is that you must file your I-130 at first, and that nothing will happen at the embassy abroad until this is approved. USCIS will handle and process the I-130 first. Once your case is approved and transferred to the National Visa Center, or NVC, USCIS no longer has any involvement in your case. From this point onward, NVC handles everything to do with your case, and they are in charge of the timeline. After the I-130 is approved, it can typically take anywhere from 1 to 4 months for USCIS to send your approval notice to NVC. Once NVC receives your case, they will generate what is called a welcome letter and a unique case number that will identify the consulate you will be assigned to. This can take usually about 30 days once your approval is received. From here on, the way your case moves and how quickly it moves will depend on the visa bulletin and your preference category. If you're married to a United States citizen, there is no backlog at the NVC, and your case will move along rather speedily, and it'll be processed as soon as NVC is ready to move. But if you're married to a green card holder and are in the F2A category, then your case can only move once the visa bulletin is current for your category. And sometimes NVC will even receive your case yet make no move on processing at all. This usually happens when your priority date is too far away, so the NBC simply holds the case until it's closer to that date. In other cases where the priority date is current on the dates for filing chart on the visa bulletin, the NBC will allow you to move your case forward. This is when they send you the welcome letter that tells you to pay the fees, and this is where you would file your affidavit of support, among other documents. Once all the documents are submitted and reviewed, then you will become what is called documentarily qualified. But even then, NBC cannot schedule you for an interview until the consulate is ready to give you an interview. And also, NBC must wait for a visa number to become available before they can schedule you for an appointment. So depending on how the visa bulletin is moving, an F2A case can pause before NBC processing even starts, after documents are submitted, or right before the interview abroad, even when everything has been completed on time. Now, in order to become documentarily qualified, it can take anywhere from 30 days to 4 months, especially if you are a paper-based case. So from start to finish, it can take anywhere from 2 to 3 months for a non-paper case and up to 4 months to 6 months for a paper-based case. And once your case is documentarily qualified, then your case will be placed into the queue for an appointment for an interview at the consulate. You can use the very useful tool from the Department of State, which is the interview wait time tool, to check for your estimated wait time for an interview. This tool will show you the current estimated time amongst every consulate around the world. And once you start using it, you can see that the wait time can be varied broadly across every single consulate. Some interviews can be scheduled by a consulate within weeks, and others can take up to a year. So when you hear somebody say that their interview is scheduled quickly, just remember that this too depends on a variety of factors. I'll include a link to the interview wait time tool in the description below. Now, there is one other issue that is causing a major impact on processing times across the world. If you are from one of the 75 countries that is designated as high risk, your case may face significant delays, extra backlog, or long administrative holds at the consulate. I'll put those countries on the screen so you can see if your country is on the list. This does not mean that your case will automatically be denied, but it does mean that consular cases from these countries are moving much more slowly, and some cases can even be effectively paused, even for spouses of U.S. citizens. Now, after the interview, if there are typically no complications, then your visa may be issued in as little as 1 week after your appointment. If the officer needs to conduct additional review or request additional documents, your timeline may end up being extended by 120 days or more. While it does not necessarily mean that you are getting denied, it will mean a delay. Then once your visa is approved, your passport will typically be returned to you within 1 to 2 weeks. The visa is going to be an immigrant visa that is valid for a period of 180 days, so you must make sure you enter the United States and use this visa before it expires. And after you enter the United States on your immigrant visa, your green card will typically be received within 6 months after entry. However, don't worry, because your endorsed visa stamp is proof of your lawful permanent residency for a period of up to 1 year before the card is produced. Don't forget to pay the fee for your green card after the consulate issues you your visa. So putting all of this together, if you are out in the United States and married to a United States citizen, your case for an immigrant visa may take anywhere from 6 to 18 months. However, if you're abroad and you're married to a green card holder, then your case can take anywhere from 3 to 6 years because of all the items mentioned above. Now, if you want to give yourself the best chance of getting approved, watch my other video, The Ultimate Guide to Proving Your Marriage is Real. In that video, I'll show you exactly what USCIS is looking for, which types of evidence carry actual weight, and the most common types of mistakes that couples make that end up costing them their case. This is one of the most important parts of a green card case, so don't skip it. I'll include a link to that video here. I'll see you there.